Hi guys, it's Kathy. I hope you're doing well. We made it to I don't know what day. Sunday, guys. Whoo! We made it to Sunday. I hope everybody who had a week last week is doing well and pain free today. It was a stressful week. Bill, I miss you. We haven't had a phone conversation in months. Like, you guys think that I've been dropping the ball on you. You don't even know the half of it. I haven't had a phone call with Bill in months. And we have some really good phone calls. Which brings me to my next topic. And I hate saying this. I don't want to say it. Next week is a bear week. Straight from hell. It's just double after double after double. Oh, Zach. I'm like you. I took a few minutes today, guys, and I found a better way to get court content. I did. Oh, Martha! Martha, hi! Martha, how's Jack? How are you? Are you doing okay? Is Jack taking care of you? Guys, Martha's here. I didn't think you were going to show up today, Martha, but you go to bed. You get out of here. We don't want you here today. You go to bed. Guys, I found a better way to get court content. I did. Which left me little to no time to get tonight's content. So we're just going to watch Boulder Courtroom R, which is acceptable. Nothing crazy is going to happen during this stream, but it'll be acceptable. It'll be a C, at least a C, if you're grading my live streams. Tonight, I love you too. Tonight is a C, hopefully a C plus if chat makes it good. But the good news is I took time away from getting tonight's ready to really get a good thing going so that soon, like, I'll be able to get the best of the best, the cream of the crop only. All right. I wrote a few more programs to scrape some logs, and I know none of that makes sense, and you don't care about any of that. So I'm just gonna tell you that I'm excited. We're gonna get good court content soon, but I work doubles all next week. I'm gonna cry. I am gonna cry. Which means I don't have time. I have no time. So next week there might be some premieres. There's gonna have to be premieres, or I'm just gonna have to cancel next week completely, because I have to sleep at some point. I'm exhausted after working a double, and my feet are like, oh my freaking Lord. Thank goodness I have Martha, because she has saved my feet, guys. I'm just going to tell you that. I can't tell you how. But Martha has made my feet all better. But I still have to literally crawl to the box. I haven't tried Opus yet. Opium maybe, but not Opus. Zach, I should look at that. I should just look at what you do and do that. Guys, I'm just gonna steal all of Zach's scripts. I have some pretty good scripts, though. I'm not gonna complain about my court scripts. I have some pretty good stuff going on here. I have some good triages. It's good stuff. Hi, Mary. It is a happy Sunday. Oh, Martha. Yeah. I used to. I do not have time. I had to stop downloading every day because I filled up. Yeah, listen, Sherry, I am working on something big that'll give me so much time, but I've just been working so much that I can't do anything. I can barely breathe. I leave the house every morning at 6:30. I get home. I get home at midnight, and then I stream every morning at 4:30. There's no time. I do not have time to do anything. I eat from gas stations and drive-thrus right now. It's ridiculous. It's not sustainable. It breaks my heart. Every time I'm in that car. I sit in my car so much. I know I could probably try to figure out a way to do the court videos in my car, but I don't have it in me. I don't have it in me. Usually that's when I get some sleep, when I have to sit in a parking lot and wait for 2 hours till my shift starts or Anthony's shift gets off or Tiffany gets off work. I have a pillow in my car. Turn on the air conditioner and take a nap at a park, which is legal. It is legal to take a tiny nap at a park during the day. And I also work on something else there, something big for me. Big, gigantic. So this week it's harder because the time I would spend catching a little nap, I'm going to be working doubles. So I'm going to do my best this week. I'm going to make sure there's a premiere at the least. I'm going to try to hit chat if I possibly can during these premieres, but man, I don't know about Cocalico School District. I know they have a lot of well, they used to have a lot of school days. They were always like one of the first to get school days, Cocalico. So we knew if Cocalico was called off that maybe we would get called off too for a snow day, but they don't really have snow days anymore, do they? Don't all the kids get iPads and work from home? I don't know. I'm supposed to be a grandma right now, not worried about kids schooling. But none of my kids have any babies yet. You're all useless. They're all useless. No one can hear me. I'm alone. God knows none of my kids are watching my stream. They think I'm stupid. Listen, guys. I have to go off topic for 2 minutes that at least 70% of you won't want to hear. At least. But we got to start saying it. We all have to start saying it. Even though none of us want to. I don't want to get political. We are not, absolutely not going to get political. We are not. I'm just telling you that now. I'm deleting anything that's slightly political. I'm just saying we have to stop being so polarized. We have to. It's not fair. It's not fair. We want justice. But if we want any healing right now, we can't have justice. We have to stop. Guys, this is it. This is the time. So this week, try to do something, anything, to make it less polarized where you are. Anything. Don't go up and punch the person in the face that you want to. Instead, give them a Hershey's kiss. Okay? Alright, just try. Just try this week. It's important that we start now, or we're going to be stuck for a while. Okay, let's get to court. Let's get to the reason why we're here. No one wants to hear that. Here we go.
For you, if it's Wednesday, it would be at 8:15 in the morning.
That's fine.
That's fine with us.
All right, so we'll go and reset this matter for September 16th, 2026 at 8:15 in the morning, and we'll go ahead and continue to have case 26M94, trail of the 26CR246 case. All right, thank you very much, folks. We'll see you then, Mr. Handley.
Good morning.
Morning.
Kelly, thank you so much. I appreciate it. Thank you. The big one. The big Hershey's kiss.
I am ready on Isaac Lovato's cases.
All right, the court is going to call cases 26M680, 26M248, and 26CR662, and 26CR1001. All of these are captioned People of the State of Colorado versus Isaac Lovato.
And Your Honor, we're asking to address bonds in 26 CR 1001 and 26 M248.
All right, go ahead, please.
Political discussions with me is usually how many F words can you fit into one sentence?
We are asking for a PR bond in each case. In 26 CR 1001, that is Mr. Lovato's most recent case. The bond was set in contemplation of felony charges, but only misdemeanors were ultimately filed. The bond wasn't changed so that the prosecution could have an opportunity to be VRA. We're asking for a bond that is more appropriate for the charges that were filed. I believe that a PR bond is appropriate. In 26M 248, it looks like a warrant was requested, and on August 4th, there was an order filed. It just says action taken, but it doesn't look like any bond was actually set. Mr. Lovato does have a stable place to stay. If released, he'd be living with his mother, and she would be able to give him transportation.
He can live with Snoopy. Snoopy, will you take Mr. Lovato in? He needs a place to stay to get out on bond. That's what we need to open, guys. We need to open a business where people can stay when they're out on bond. We could charge them for their drug tests. I'm sure we could find a few of us in chat that would be happy to perform the drug tests.
To court, he does have job prospects waiting for him. He was supposed to have a work interview yesterday, but he does believe that he has a job lined up with Longmont Florist. He also has support out in the community through a therapist who he does see.
Oh, dear Lord. There's an S on the end of that, Kelly. How many cats did you find? Then we should open a Motel 6, Bill. That's what we should do. I just think collectively we should start a business and make some money. Kelly, how many cats do you have now? We need to rediscover impulse control. Mary, you're so right. 100%.
He has talked to me since I've represented him about all the resources that he is in contact with, all the support that he has out there through treatment, through doctors, and through counselors. He does not have much money that he would be able to put toward posting bond. He maybe has about $500. His mother and Mr. Lovato also care for his niece and nephew. He tells me he was doing everything he was supposed to be doing when he was out of custody. I believe that a PR bond is appropriate, or at least a reduced bond.
All right. Thank you, Ms. Seaman. From the prosecution.
Yes, Your Honor. Emily Norwood for the people. On 26M 248, I don't object to a PR bond. On 26 CR 1001, I do object to a PR bond. However, I do not object to a reduction of bond at the court's discretion, noting that only misdemeanor charges were filed.
All right. Thank you. All right. The court has had an opportunity to review the original bond application in this case of note, and this is while I'll be issuing a secure bond, but it'll be a reduced bond. I note that the CPAC category was ranked 3, and there's a
We need to rediscover impulse control. Smile, guys. Just smile at other people. When you're driving down the road, they're not a jerk. They're just trying to drive. They're not trying to be a jerk. Zach, thank you so much for the $5. Oh my gosh, you got Terry! That's awesome. Thank you so much, Zach. Thank you.
DVSI score of 20. The court notes that a DVSI score above 11 shows a higher risk. So the court does not feel that a PR bond in the 1001 case is appropriate. The court is going to note that currently the bond in 26 CR 1001 is set at $25,000 cash, surety, or property. Given the charges that are in place right now, the court is going to reduce that to $3,000 cash or surety with the same original terms and conditions, which and I will offer or authorize a cash option on that. So it would be a $300 cash only option. Conditions to include no alcohol, no drugs, no weapons, to comply with the firearms relinquishment order within 7 days, substance use monitoring at the discretion of probation, no contact with the victim, pretrial supervision by probation and report to probation within 24 hours of release. The court is also going to order as a condition of bond that he comply with the mandatory protection order. And then in the 248 case,
Michael, I'm thinking about asking everybody for money for you. I think that you should go to veterinary school and become a veterinarian. I feel there's some animals out there that might need your attention so that you can make them feel better. Think about it.
the court notes that currently his bond is set at $2,000 personal recognizance. I don't know if it makes better sense just to combine the two probation complaints and not set an additional bond, because it doesn't make sense for him to do an additional bond since he's already technically on bond. And so what I will order, and it might look clunky, is that the court is going to combine the probation complaints 1 and 2 into a single complaint. And the court notes that Mr. Lovato is going to remain on bond that was originally set back on March 23rd, 2026, the amount of $2,000 personal recognizance. Again, the conditions of that are no contact with the victim, not pretrial supervision, but report to probation within 24 hours of release, and comply with all conditions of probation. Anything else that the parties are looking for?
Nothing from the people.
All right. And so with that in mind, we are scheduled today for...
Judge Bobby wants him to go to jail. Or her, I wasn't paying attention. Bobby wants them to go to jail. Enough of the pronouns, people. Come on.
Oh, I'm sorry. We're scheduled, I think, next week for an arraignment. Am I right on that?
And Your Honor, we are. Could we set that court date out to September 18th?
Any objection?
No, Judge.
Does September 18th work? Yes. All right. So we'll go ahead and set an arraignment, and this is on all three cases, to September 18th, 2026 at 8:15 in the morning. And so if Mr. Lovato is able to bond...
Jen, guess what I did today? It only took me like 10 minutes, so it really wasn't... I really didn't take too much time. I didn't. So my yard is rocks. There's some dirt there, but it's like when you try to dig into my you get the shovel to the grass, it doesn't go down anywhere. In my dirt is so many rocks. It's unfreaking believable. So today, I know, Jen, you're going to be horrified, but it'll work. I promise. It'll work. So today I scraped like a foot circle of grass off the top of the dirt rocks. And I bought dirt with no rocks in it. And I tried very hard to remove as many rocks as I could. And then I put a butterfly bush. I don't know what it's purple. It's purple. It's like lo and behold, I don't know what it is. It's a butterfly bush. And I stuck that on top of the dirt. And then I got the dirt that I bought. I piled it up around the root ball. So I didn't really plant in the ground a butterfly bush, but I bought ground to put around a butterfly bush because I have humongous monarch butterflies in my backyard, a bunch of them. I was thinking of you the entire time I was doing this, Jen. I'm like, yep, I'm just like Jen. I'm planting. All right, maybe it won't work. I will go buy more dirt if the rain washes all the dirt away. I know that's possible. So I'll buy more dirt. I'll figure it out. But at least I got something there for the butterflies so they have something to eat.
And he'll need a report back to this courtroom on September 18th, 2026, 8:15 in the morning. Otherwise, he'll be brought over by sheriff's deputies. Anything else?
No, Your Honor.
All right. Thank you, folks, for appearing.
Thank you.
Good morning.
Good morning.
We're ready on Christina McMahon's case.
All right. The court is going to call case 25 CR 995. This is People of the State of Colorado versus Christina McMahon. Let me go ahead and get quick entries of appearance.
Shannon Hotzinger for the people, Your Honor. I'm covering for Miss Kokomo Metzger.
All right. Thank you.
Cameron Bedard for Miss McMahon. She's present.
All right. Thank you, Ms. Bedard. How are we proceeding today?
We have a plea. We're ready to enter that plea, and we also intend to go to immediate sentencing.
All right. All righty. So before we go and enter the plea, what I'm going to do is just give a general advisement to the courtroom. And so if anyone is in the courtroom that's going to be entering a plea today, please listen closely. You have the following rights. You have the right to be represented by an attorney. If you can't afford an attorney and are found to be indigent, the court will appoint an attorney for you at no cost. You have the right to enter a not guilty plea in this case and set this matter for a jury trial. You also have the right to be presumed innocent and not guilty of these particular charges, and that presumption of innocence will stay with you up and until a point in which a jury has found you guilty beyond a reasonable doubt. You also have the right to require the prosecution in this case to prove its case beyond a reasonable doubt. You have the right to confront and cross-examine all witnesses that are brought against you. You also have the right to have the court issue subpoenas to compel witnesses to testify on your own behalf. You also have the right to remain silent throughout the case. You also do have the right to testify on your own behalf. If you decide that you'd like to testify on your own behalf, you're going to necessarily be giving up your right to remain silent, and you can be cross-examined. And then if you were found guilty, you have the right to make a statement on your own behalf before the imposition of sanctions. Before the imposition of sentence. And of course, you have the right to make an appeal to a higher court if you feel that the lower court has made any errors during the trial process. And so please keep those rights in mind if you're going to be entering a guilty plea. With regards to this case, what is the proposed disposition?
This is 12-month deferred judgment, Your Honor, to a criminal mischief.
So just to clarify, Your Honor, she'll be pleading guilty to an added count 2 of criminal mischief as a class 1 misdemeanor, and that will be and act of domestic violence that will be pursuant to a 12-month deferred judgment and sentence.
Right. And is there paperwork that's been uploaded that I just haven't seen yet, or do you have paperwork now? It has been uploaded?
Yes.
There we go. Got it. All right. And are there any other conditions of the deferred sentence that you'd like to place on the record other than what's in the agreement, which looks like conditions of the deferred sentence would include an alcohol evaluation and treatment as recommended, a substance abuse evaluation and treatment as recommended, domestic violence treatment as recommended, a mental health evaluation and treatment as recommended, continue to comply with the mandatory protection order, conditions of substance abuse monitoring, no alcohol, no drugs, no weapons, and no new law violations. Are there any other conditions? All right.
No, Your Honor.
All right. Alrighty. So, Ms. McMahon, I've been told that you are willing to enter a guilty plea today, and that for the purposes of this plea, you're going to be pleading guilty to an added count 2. That's a charge of criminal mischief between $1,000 and $2,000, a class 1 misdemeanor. In exchange for that plea, the people are moving to dismiss count 1, which is a class 4 felony of criminal mischief. Is that your understanding?
Yes.
All right. And how old are you?
60.
How far have you gone in school?
Bachelor's degree.
All right. And although we've been speaking, I have to ask this question. Do you read and write and understand the English language?
Yes.
All right. Now you're represented today by Mr. Bedard. Are you satisfied with his representation of you in this case?
Yes.
All right. Have you been consuming any drugs, alcohol, or intoxicants that would make it difficult for you to understand what is going on today? All right. You've heard the...
Do they work? Do they give butterflies food? I just want to make sure that they have some food before it gets cold, because it gets really cold here.
proposed disposition in this case. Is this how you'd like to resolve your case?
Yes.
All right. The charge that you're going to be pleading guilty to states as follows: that on or about April 25th, 2025, that you, Christina Ingram McMahon, in the course of a single criminal episode, unlawfully and knowingly damaged the real or personal property of Doug Wood, the aggregate damage being $1,000 or more, but less than $2,000, in violation of Colorado law. Do you understand the elements of that particular offense?
Yes.
That charge, which is a Class 1 misdemeanor, is punishable by a jail sentence of up to 364 days in jail and a fine of up to $5,000. I'm advising you of this just so you know what the maximum possible penalty the court can impose in this case. You understand that in this case that you are being offered a deferred sentence, but ultimately any kind of sentence imposed would be up to the court's discretion. Do you understand that?
Yes.
All right. Do you have any questions as to the rights that I have explained to you today? Understanding those rights, how would you like to plead guilty to an added count to criminal mischief? Guilty or not guilty?
Guilty.
All right. And is there a factual basis or a waiver?
We waive factual basis.
All right.
Judge.
The court will accept a waiver of the factual basis in this matter. I will go ahead and allow the guilty plea to enter, but I'm not going to, I will suspend it based on the deferred judgment and sentence. Let me go ahead and hear from Ms. Hutzinger with regards to any sentencing.
Your Honor, I would just ask the court to impose the sentence as stipulated, that people are in compliance with the VRA with respect to this disposition and the victim thinks it's appropriate. There's no restitution being requested.
All right. Mr. Bedard.
Just briefly, Judge, Ms. McMahon is taking accountability. This was an unfortunate lapse of judgment after a really negative breakup. This resolution allows her to go on leading a life without any convictions ultimately when she completes her deferred judgment. I've got no doubt that she will. She's prepared to take accountability today. She's a great mother with 2 boys who she loves dearly. This was an embarrassing mishap, nothing more than that. I think this is a fair disposition. We would ask the court to accept it.
All right, thank you. Ms. McMahon, your attorney said very nice things about you, and I understand that this is a first offense of any kind, and so I have a kind of a good understanding of everything that's going on. That being said, you have the right to make any statement that you'd like on your own behalf today, and I would welcome you to do that if you would like to. All right, thank you. All right, the court is going to find that the proposed disposition in this case is appropriate based on the lack of criminal history and the overall facts. The court will go ahead and impose a 12-month deferred sentence. That'll be supervised, and we'll give you paperwork today to respond to adult probation to get that supervision started. The court is going to order the conditions that are contained.
I was thinking of you and Monica today, Kelly. That song came on. Oh, gosh. I can't remember what it's called. It's a country song. I don't do country much. I like country, but I don't do country much. Usually I'm in a relationship when I'm listening to country music. It's that song. Oh gosh, what was it? You know she's from Texas. You know that girl's from Texas or whatever. Yeah, I know you two know what I'm talking about. I just can't describe it any better.
In the deferred sentence agreement form, which includes an alcohol evaluation and treatment as recommended, a substance abuse evaluation and treatment as recommended, and my guess is they'll combine those two. A domestic violence treatment as recommended by a domestic violence evaluation, a mental health evaluation and treatment as recommended, no contact with the victim, and to comply with the mandatory protection order, conditions of substance abuse monitoring at the discretion of probation, no alcohol, no drugs, no weapons, and no new law violations. And that'll be the order of the court. Mr. Bedard will probably have some paperwork for you here in just a second. So if you'd like to have a seat with your client, we'll call you up in just a minute.
Thank you, Judge.
Good luck, Ms. McMahon.
Thank you.
Ms. Land? Oh, you're fine. I was anticipating you might have something ready. Yeah. I appreciate you hanging out with us, though. Ms. Seaman, go ahead, please.
Good morning, Judge. Madeline Malcolm. I was wondering if we could call Trevor Arrett's case.
All right. Thank you, Ms. Malcolm. I apologize. I'm sorry, which case are you looking?
Trevor Arrett.
All right.
Jacob Arrett. Oh my gosh.
There you go. You're right. You're good. I mean, we're just having issues with names this morning. It's a Friday. All right. The court's going to call case 26 CR 667. This is People of the State of Colorado versus Jacob Arrett. And Mr. Arrett, do I have you appearing in front of me today?
Yes, Your Honor.
Thank you for appearing. All right. Ms. Hutzinger, thank you for appearing. How are we proceeding today?
Judge, I would ask for a set of about 45 days for another arraignment.
Jen, thank you so much. I appreciate it. Thank you. Panic at the Disco. Oh, Panic at the Depot.
All right. Ms. Hutzinger, this is a second arraignment. Any objection?
Given it's just a second, I have no objection.
All right. So the court will allow this matter to be set over for about 45 days. Let me go ahead and see what date we can offer.
That works for the people.
For you? It would be in the morning.
Maybe,
That work
Kelly.
okay?
Yes.
That sounds right.
And so, Mr. Arrett, we're going to continue your matter till September 25th, 2026 at 8:15 in the morning. That'll be back here, all right?
Yes, sir.
All right. We will see you then. Thank you for appearing.
God bless Your Honor.
Ms. Dolan, are we just waiting for a match for you? Okay. Whenever you're ready. Locked up. Okay. Just prop. Oh, it's propped, it looks like. I was going to say, let's just prop the outer door for now, but it's already propped, so we should be okay.
Your Honor, I am ready on Antoinette Araguin's case.
Court is going to call case 26 CR 342. This is People of the State of Colorado versus Antoinette. Is it Aragon? Araguin, thank you.
And Shannon Houtzinger for the people.
All right, how are you proceeding today?
And we are
Thank you for the jewels, Jen. Thank you so much.
asking for a continuance to September 18th.
Is that date still available? Yes. All right. All right. Any objection?
No objection, Your Honor.
So we will go ahead and reset this matter for a third arraignment, and that will be on September 18th, 2026 at 8:15 in the morning. And so, Ms. Aragon, you'll come back here at this point on September 18th, 2026 at 8:15. Please stay in touch with your attorney, all right? All right. Thank you for appearing.
We're ready on Mr. Pettis.
All right. The court is going to call case 26 CR 501. This is People of the State of Colorado versus Ethan Pettis. Mr. Pettis is in custody. Ms. Dolan, do you want to enter your appearance for me, please?
Yes, Sydney Dolan appearing with Mr. Pettis.
All right.
And Bradley Sherman for the people on behalf of Ms. Van Nuys.
Thank you, Mr. Sherman. How are we proceeding today?
Your Honor, I'd like to address bond today, and my understanding is that the people are.
Did any of you have kids in school that went to didn't? No, that's the wrong question. Did any of you have kids in school that had to do IXIL, or wasn't it IXIL? Could have been IXL, but I think it was IXIL. It was that math program that you had to log in and do the little math games and stuff for school. Because there's a Mark Willis, an IXIL Excel interpreter. I wonder if he's just gonna interpret math problems for us. It's possible, we don't know. Does anybody here know how to speak Excel? I wonder what Excel's from. It could be Lixel, I don't know. I think it's IXIL. I'm not gonna Google it. I'm just gonna go with it.
We're also prepared to do that.
All right. Hang on for 1 second.
And that's correct, Your Honor. We are prepared to address it.
All right. Stand by. All right. Go ahead, please.
So, Your Honor, this is a case in which the bond is set very, very high at $500,000. I would say that is out of line with what is normally set in this type of case in this jurisdiction. I want to ask the court to reduce Mr. Pettis's bond to $100,000 or below. Just to give the court a little bit of history, when we first appeared at the jail and bond was addressed, the only other time that it's been addressed in this case, the people requested a $200,000 bond. I have to assume that the people's position has not changed because they took that position at that time with the exact same set of information that we're working with now. There has been no new information at all in this case that I think would plausibly or reasonably change that position. That sounded high to me at the time, and I think everybody was surprised when the bond was set as high as it was. I know the court has access to the affidavit in this case, and there are some things about the fact pattern of this case that are unusual, specifically the volume of the communication and statements that are alleged to have occurred between Mr. Pettis and the named victim. What I want to ask the court to look at is the actual, not the talking and the back and forth, but the actual objective, real data that's available to the court here, which starts with the fact that Mr. Pettis is a person who's 27 years old and has absolutely no criminal history. He is a CPAT.
We get someone with a $500,000 bond in, and here comes my Sodak crew. Sodak! Hi, Kristen!
Category 1. The strongest evidence that I can think of for the proposition that he will return to court, that he will comply with bond, that he will do what he needs to do, has come from his own behavior. I was in touch with the detective who was investigating this case while it was being investigated. And during that time, Mr. Pettis and his parents said to me that Mr. Pettis had gotten accepted to a Spanish language educational program in Argentina. And I said, sure, you can go to Argentina. There's no reason you can't. You just need to understand you're coming back here the minute a warrant issues, and I don't know when that will be. The warrant issued on April 17th. Detective Porter told me about that on April 22nd. And Mr. Pettis at that time was in a remote region of Patagonia on a hiking trip. And I got a hold of him, and he was on a flight on April 26th. He wasn't extradited from Argentina. Nobody made him do it, but that's how fast he made it happen under circumstances where it was just totally voluntary. So what I'm asking the court to do is to reduce this bond to $100,000 or lower and to allow him to go home to Mississippi. Mr. Pettis has been accepted into a dual diagnosis treatment program there at a place called Pine Grove. I have a copy of the acceptance letter if the court would like to see it, and I've already shared it with the people. I think that it would be hard to argue that on the facts of this case on their face, I don't think you can say it doesn't involve serious substance abuse, serious mental health problems. These are things that need to be addressed, not just for Mr. Pettis's welfare, but frankly, for continuing community safety concerns. If the court is not comfortable allowing Mr. Pettis to return to Mississippi, that's fine. I am still asking for the bond reduction down to $100,000. I truly believe that that is what is appropriate here. Mr. Pettis has been in jail, again, a person with zero criminal history, for 102 days now. He's in terrible shape. The mental health problems and other problems that are so apparent in the affidavit in this case and in the facts have only continued to intensify. So I really would.
Ma'am, are you saying that his mental health problems are intensifying? So we should let him out of jail? Is that what you're trying to tell the judge? Good plan. Good. I like the way you think. It's like reverse psychology. Make him feel too dangerous to stay in jail. He might hurt another prisoner.
Prevail upon this court to modify the bond in that way. And if the court has any questions for me, I can certainly answer those.
All right. Thank you, Ms. Dolan. Go ahead, Mr. Sherman.
Thank you, Your Honor. I would object to a modification of bond. First, addressing the people's initial bond recommendation. I was looking through the notes, and it looks like...
Kristen, I have had the musical 6 stuck in my head for like 7 days now. I almost said 6, but I changed it. But now you gave me a Vita, so I can... I can go crazy over something else for another week.
This case was added onto the docket late, so the jail deputy actually didn't have time to do a thorough review of the facts, and that's why she made that initial $200,000 bond or $200,000 request. However, I think it was Judge Martin caught it and said, whoa, this needs to be set higher, and that's why he set it at $500,000. The facts here are extremely concerning for the people. We have victim safety concerns, community safety concerns, and I'm especially opposed to him returning to Mississippi, where he would be back with his parents, specifically his father. His father has made comments about helping his son commit suicide if he is facing a lengthy jail sentence. He has made comments about helping his son flee justice, essentially. So because of the community safety concerns and because of the comments that his father has made.
I get it. That was huge shock value. I get it, sir. But you cannot keep this guy in jail because of comments that his father said. I mean, look, I get it. They were shocking. They were. But he didn't say it. His father said it. And you can't just I want him to stay in jail. I do. I don't want him out. I'm not rooting for him to get this bond lowered. First off, I don't understand what the difference is between a $100,000 bond and a $500,000 bond. They are equally unreachable. Neither. I wouldn't get out of jail for either of them, so it really wouldn't matter whether it's a 1 or a 5. Big deal. Oh yeah, now I can do Chicago too. But I still think that this lawyer just did something underhanded and not legal. I just don't think. The dad is a piece of crap. He is, Bobby. Maybe his dad should be in jail too. But legally, you can't keep someone in jail because of something their father said. Or I would be for You guys would never see me again.
About helping him avoid justice and consequences in this case, we would object to a modification. For VRA purposes, we did reach out to the victim. We got her position. She said that she was essentially deferring to the court, but that's because she has relocated. So she doesn't feel like she is facing a direct threat from the defendant. However, the people have to look beyond just the specific victim in this case and look at the community, and we still have those community safety concerns.
And Judge, may I respond very, very briefly?
Well, actually, hold for 1 second because I just have a couple of questions. And so I think, Mr. Sherman, what you're telling me, the largest concern here is that he's not going to appear.
That's correct. Yeah,
All right. I mean, I understand there's a community safety concern, and I think that weighs a little both ways. And the only reason I'm saying that is I can see the safety concern, but I can also see having better community support, being with family, could be considered a positive. I don't know if you agree with that or not. I know you have concerns about his father and what his father said, but I'm thinking more about a dual diagnosis treatment facility that he would be attending, that I can make a condition of his bond. So I'm curious, with that in mind, if you still have the same concerns with regards to the Mississippi move, in part, there's lots of non-monetary conditions I can do. Not forfeit, but to surrender his passport as a condition of bond, so we would hold on to his passport, and that would keep that particular issue at bay. Condition that he enter into this treatment program. I have questions from Ms. Dolan as to the length of that particular program and doing that particular aspect. And so kind of with those issues, which I think can be handled with a non-monetary, I just want to make sure that there's not other areas that you're worried about. And again, I'm clearly concerned about threats of suicide and that aspect. Any kind of devaluation of human life, even your own, puts the community generally at risk. And so I believe that that's an issue. But again, when I'm looking at if he's doing a dual diagnosis program where he's receiving mental health treatment, isn't that more stabilizing than it is destabilizing when it comes to the bond? But I just wanted to hear your response to that.
I take the court's point. I think the people's position is still that we would object to a modification. However, if the court is going to make that modification, I would ask the court that bond is only modified to the extent to allow the defendant to go into this treatment program, that it would be a condition of his bond. And I would very much ask the court to not allow him to travel out of state, specifically to Mississippi, because I don't think that his parents are going to help him in any way.
All right. And I didn't get that from you, Dolan, as to where this treatment program is, if it's local or if it's back in his home in Mississippi, but I'll have you respond to that as well. Go ahead, please.
So the treatment program is in Mississippi. It is an hours, I'm not sure how many hours drive from his parents. It is a 60 to 90 day program initially, and then would need to be revisited. I want to address the concerns that people are expressing about statements by Mr. Pettis's father. And the only thing I can really say to respond to those is there's nothing other than the named victim who has said, to put it mildly, a lot of things saying that Mr. Pettis's father said that. I don't think there's anything to suggest or show that he would think that he would say that. I've been in very close touch with him for many months, including during the winter, long before this was charged. And that sounds so totally foreign to anything I've ever heard from Mr. Pettis's parents. In any event, though, I am not asking the court to allow him to live with his parents. I hear that that's a concern of the people's. I heard from Judge Martin that's a concern of his. What I'm asking the court to do is to allow him to return to Mississippi specifically for this dual diagnosis program. Now, I think it would be nice if he could be in a program here in Colorado, but he can't because his health insurance just simply will not cover that. This is what is possible given his health insurance. His family cannot pay out of pocket for that. I also want to mention that this is not something that people have brought up today, but I believe it was brought up before. The alleged victim has talked about Mr. Pettis's parents as if they have a lot of money, and they don't. Mr. Pettis's mother's income is $25,000 a year. His father's income is between $100,000 and $150,000 a year. These are not people who have a lot of money to throw around by any stretch of the imagination.
Okay. This is it, guys. This is an opportunity. Now, at first, that might have ticked a lot of us off. Because I'm going to say $175,000 is a lot of money They actually do, in fact, make a lot of money. $175,000 a year is a lot of money. But listen, we're not going to be mad at them because they make a lot of money, and she just brushed it off like it isn't. I did miss you guys. I absolutely, but you don't understand, Kelly. I talk to you guys all the time in my head. When I'm going through my day at work, I'm like, oh, Monica would have loved that table. Oh my God, she would have been so mad. Or Kelly and that guy would have had a good conversation about that. Listen, we're all connected. We're going to be happy that they make that much money. Good for you guys.
And what's happening now, and frankly, what I think that Judge Martin's intention was to set the bond too high for somebody to post pending further information and pending a better plan. It's no bond, right? Functionally. So if the court has any other questions, I can address those.
Tell me about the program. And the reason I say that is, like, for example, is this a program that he's on the waiting list for and he might get in the next 30 days? Is this something where if I authorize a reduction of bond, he's on an airplane and is going to be entering this particular program? What's going on?
He'd be on an airplane.
No, Judge. Is he locked up in that program? Can he walk out the front door in the same city where the victim lives? That's the question, Judge.
And would be entering it. There is a bed available today. And what I would suggest to the court is to craft a modification of the bond that would, as the court said, that would make that a condition of bond, right? That pretrial supervision would monitor that he would be released only to do that. I don't know if a GPS ankle monitor would be helpful in this regard, but yes, there is a bed available right now.
All right. And folks, I hate to admit, but I've been out of the rotation for criminal for a while. What is the status of the availability of GPS monitoring?
Your Honor, I don't
And
know.
Mr. Sherman, I'm absolutely aware. I thought I heard a little bit back and forth. It is not active monitoring. It's passive monitoring.
Yes.
And so the idea that if it's passive monitoring, for example, I could set a geofence around this facility in Mississippi, which indicates that as long as he's there, he's in good shape. And if he leaves, it would alert. And again, I understand it's a passive alert and would only be downloaded at the end of the day. So it's not like some active alarm is going to say that he crossed that geofence, but it would be something that would, I think, assuage a lot of the concerns that you have, which is that he could be a flight risk. But go ahead. If you have more information, I just didn't even know if GPS is available still.
No, what you heard is the information I have. I guess the only clarification I'm looking for is Ms. Dolan was saying this program's 60 to 90 days. I mean, does he get released from the treatment program at the end of the 60 or 90 days? Like, how does that work?
It would be reassessed.
And I think that what I would do is I would craft the conditions of bond that within 7 days of any release, he needs to return to Colorado for at least a status conference to see where things are. I don't know, for example, and again, Ms. Dolan, I need more information from you on this. Would he have access to appear in 30 days, 45 days remotely over WebEx just for a check-in if we need to do that? I don't know if the prosecution would be comfortable saying, well, let's just wait the 60 days and kind of reassess at that point. And I don't want to unnecessarily schedule for a hearing if he's not going to be able to access it. But I think that, again, there's some non-monetary conditions that I can address that can, I think, help some of the concerns that I've heard here from both sides today.
And I do like the court's idea, if it's possible, to have a status in the middle of his treatment program so that we're not having to figure out what's going on after he's being released.
Sure.
And I don't know. I don't know, Judge, if he'd be able to appear for that. I'm assuming that he would, or alternatively, that somebody from the program maybe could appear. I think we could figure it out.
All right. Anything else, Ms. Dolan, that you want me to know?
No.
All right. All righty, folks, here's what I'm going to do, and I'm going to go slow. So on this. So on condition that he enter, and what's the program called?
Pine Grove Behavioral Health and Addiction Services.
All right. All right. So the court is going to grant the request for a bond reduction as follows. On condition that Mr. Pettis attend the Pine Grove Behavioral Health and Addiction Program in Mississippi, which the court understands to be a 60 to 90-day program, the court will reduce his bond to a $100,000 cash or surety bond. The conditions of bond will be as follows: that he must attend and not voluntarily discharge from the Pine Creek program, that he have no contact with the victim. I'm going to allow for pretrial supervision still by community justice services. He needs to sign a release with Pine Grove that will allow community justice services the ability to verify his residency there and that he's continuing in treatment there. The court is not going to require that he sign a full release to talk about the treatment that he's doing, but just that he is attending there and has not left the grounds. The court is going to order conditions of no alcohol, no drugs. With regards to the drugs, if there's any kind of mental health medication, he'd be allowed to take that with a prescription only. Condition of no weapons. I'm going to order that he surrender his passport prior to his release, and I'm going to authorize that he be able to return to Mississippi. In order for him to be released on the $100,000 bond, I just need to have a confirmation letter indicating that he's been accepted into the program, provided to the court, and then with a copy to the jail staff as well as the prosecution, just indicating, yep, here it is, his bed's available. I'm also going to order as a condition of bond that he be on passive GPS supervision, and I'm going to set the geofence that he needs to remain within the confines of the Pine Grove Behavioral Health and Addiction Center.
And regarding the letter, I do have a letter right here saying he has a bed available as of August 6th.
I assume
Should I
you
just
did.
file that?
Yes.
Okay.
Mr. Sherman, other conditions of bond that you're asking for at this point?
I think the court covered all of it. Thank you.
All right. Ms. Dolan, anything else we need to address right now? And did you all get everything? Okay, perfect. Thank you. And so we need to set this now for a review. And Ms. Dolan, since we're looking at 60 days when the first kind of benchmark is going to be met as to when he could be released, does it make sense to set it again about 45 days out just to see kind of where things are? And I'll authorize Mr. Pettis to appear remotely. And Ms. Dolan, if you
Swampy is a good way to describe it, because when it's been, so we have the Canadian wildfires. They covered everything for a while, and then it keeps coming back. So there's so much fog, and then storms like you wouldn't believe this summer. I just cannot believe some of the storms that we had this summer. We had like 100-year-old trees just sheared. The winds just completely, I counted, I think 50 trees in this one little development just gone. And the bases were like, I don't know, 2 feet wide. They were huge trees. And then the days when it's not storming, it's so freaking hot. I think my boss's watch 2 days ago said it feels like 101 outside. It was only 80 some degrees, but it felt like 101. That's the biggest jump I've ever seen a watch go, when your watch tells you how hot it feels outside. And if it's not raining though, it's so freaking hot you're sweating buckets and buckets. We had a ceiling tile. Okay, where I work, all the drinks are in this sort of tunnel in the building, and it's on a slope, this tunnel. Okay, so there's no stairs from the kitchen to the dining room. It's a ramp, a hill, and the light in there, the acoustic ceiling tile, there was so much condensation with the air conditioning units that it was just, everything was just sopping wet, and the ceiling tiles broke and fell because it was, we have 2 carpets in the tunnel so that we don't slide when we're trying to walk up and down it because the drinks are there, and they were just sopping wet which made the rest of the tunnel floor wet. So everything, where we do most of our work, where we clear the plates, when we clear off a table, we clear the plates, and where we get more drinks and everything, it was just, we had to walk around the rain falling from the ceiling, and we had to step through these soaking wet carpets and then onto this slippery end of this ramp just to get drinks in and out, because it's so hot outside. The air conditioning, even in my bedroom, it keeps filling. I have a mini split in my bedroom, and I don't know if any of you know what that means, because I didn't until a month ago. But it's like an air conditioner unit, ductless. There's no ducts in the wall. So I have this big trash can sitting under my mini split, and I have to keep dumping it out. And when I work a double, I don't make it in time. So when I get home from work this week, every day this week, it's just my carpet in my bedroom's going to be all wet. So I have to figure something out. But yeah, the rain is, it's either rain, pouring down rain, which is great for my daughter, because she works for a roofing company, and every single time it rains, she gets super busy. Well, she's just been balls to the wall working every day right now. Everybody's roof is leaking right now, and with the winds breaking the siding off people's houses, it is, yeah, I'm going to have to get a bigger trash can. I'm trying to think. I'm going to have to roll my trash can that you take out to the street. I'm going to have to roll that up to the bedroom to make it through a double. I'm going to have to. I don't see any other way. You know how we used to have the strings where you would like make a long string out of masking tape or out of yarn or whatever, and you could make the water go into like a tub or something? I could try to do something like that. We used to do that back in the 80s. But I don't know. No, there's no ceiling. There's no ceiling at where I work anymore to fall down. It's all gone. It's all the tiles came down. It's just bare now, so there's nothing to fall. It's just dripping in spots that we have to keep buckets underneath. It's just, who knows? Maybe this week will be a little more nice outside, like 70s maybe, instead of feels like 150,000 degrees. I don't know. It won't matter to me, because time is just going to keep marching on, double after double after double. I just watch a clock 24/7.
Just inform the court by motion if he somehow doesn't have access to any kind of electronics or the ability to appear, and we can address that as we go. But let's set a status conference out about 45 days. Ms. Dolan, are you all right not setting this for a second arraignment at this point?
Yes.
Okay. Let's look at 45.
That works with the people.
That works for me.
All right, so we'll set this matter for October 2nd, 2026 at 8:15 in the morning. Again, the court will authorize Mr. Pettis to appear remotely over WebEx at that point. Mr. Pettis, you just need to stay in touch with your attorney. She'll provide all the information on how to appear on that. Ms. Dolan, anything else we need to address?
Thank you.
All right, that'll be the order of court. Oh, go ahead.
500 and 100,000 to all these conditions.
Correct. Yes, that helped. And that, is it
I
clear?
don't know if it was going to 100,000 or if
It's contingent on the acceptance into the program with proof, with a GPS monitor and the like. All right. Thank you, Ms. Dolan. All right. Thank you, folks. Mr. Pettis, we'll see you in about 45 days, sir.
Yes.
Yes.
I can make a copy for you. I can make a.
Cash or surety? Yes. No cash only option. Oh, great. Okay. Deputy, do you want a copy of that letter?
Yes, sir.
Okay.
Thank you.
Sure. If we can do an extra copy. Perfect. Thank you. Whenever you're ready.
Oh, sorry. We can call Drewy Hood.
Okay. All right. The court is going to call the following cases: 26M636, 26M711, 26CR490, 26M146, 26CR919. These are all people of the state of Colorado versus Drewy Hood.
Emily Norwood for the people.
Madeline Malcolm for Mr. Hood.
Thank you. And I am not seeing Mr. Hood.
Oh, sorry.
Ah,
Guess I
excellent.
didn't tell him to walk up here.
All right. All right. And so there is, again, the 26M711 case out of Longmont that I'll need to address with everyone. But go ahead and kind of let me know what we have going on today.
I'm covering for Miss Land. It seems like the biggest issue is that there's an active warrant on the new case.
Right.
I've spoken to Miss Norwood. She's not objecting to a modification of bond on that case. So
Okay.
what we would be asking for is either to quash the warrant or modify the bond to a PR bond so that he could post it at the clerk's office today, acknowledging that he showed up here knowing there's an active warrant.
And that's accurate, Judge. I would note that I've extended an offer that would include probation as well as dismissing that case, so I don't think it makes sense to hold him on it.
Got it. Okay. And then for the remaining cases, what are we going to do?
I believe we're asking for a set over, Your Honor, but I'll let Ms. Malcolm speak on that.
Okay, Ms. Malcolm.
Yes, Ms. Land is asking for a set over for about 30 days. And then she gave me a few days that she's not able to accept.
All righty. Let's go ahead and see with a setting of all the cases about 4 or 5 weeks out.
Yes.
That works for me.
All right. So we'll go ahead and reset everything until September 9th at 8:15. And so that's a Wednesday morning. And so, Mr. Hood, you need to come back here at that time. With regards to case 26M711, the court is going to note that it's currently an active arrest warrant for Mr. Hood's arrest. And specifically, this is with regards to an offense, a violation of protection order. I'm noting that it says that there is a stalking or domestic violence factual basis. And I just need to confirm that this is not one of those situations where this offense has an underlying factual basis of domestic violence, which I think does mandate an arrest pursuant to statute.
I understand that, Judge, and I also show that in the court file, it reflects that this is a stalking or DV basis. However, when I pull up the actual charging document, it does not appear to be charged that way, and it's my position that it's not currently charged that way.
All right. All right. And so with regards to the 26M711 case, based on the representations of the prosecution, the court will go ahead and modify the bond in this case to $1,000 personal recognizance bond. I'm going to set the following conditions. The court is going to set conditions of no contact with the alleged victim, pretrial supervision, and that pretrial supervision will be done by Community Justice Services. Are you currently seeing them right now?
Yes.
All right. And so what's going to happen after court today is you're going to have 2 places that you need to go to. One is downstairs to the clerk of courts. At the clerk of courts, they're going to process the paperwork where you can sign a personal recognizance bond. We'll go ahead and let them know the date of that and get you a setting notice so you can give that to them, showing when all your other cases are set so they can match that particular date.
I wonder what has to change before we don't have dockets just full every day over and over of domestic violence. I mean, there's so many crimes out there. There's so many. We should have dockets every day that are just a plethora of different crimes. But we have DUIs and domestic violence over and over and over and over and over. I wonder what has to change. We need a few other crimes, though. We need, I don't know, Micah, are you still here? Name some odd crimes that we should at least see every once in a while, but we don't. We just see the same things.
And then you're going to need to go up the hallway on the first floor to Community Justice Services, where you will need to check in with your pretrial supervisor at that point to let them know of this new case and that you're also on bond in that case. Does that make sense, Mr. Hood?
Yes, Your Honor.
All right. Any other things that you think I need to do with regards to this case before I just go ahead and reset everything to September 9th, 2026?
Nothing from the people, Judge.
All right.
Nothing from defense.
All right. And so all the matters are going to be reset for September 9th, 2026 at 8:15 in the morning. We will get, again, that setting notice so you can go downstairs. We will make the changes in the system showing that the bond is a personal recognizance bond, so you're able to post that bond at the clerk's counter. There is going to be an order, and I need to prepare it for next time, but we need to get...
People are too scared to steal horses. That's like death sentence. You hang for that. But you know what are really good cases that we see every once in a while, but we don't see enough of? Tree cutting. When you cut someone's tree, like your neighbor's tree, like that's a big deal. That's a big, 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 big deal. We need more tree cutting cases because they are always outstandingly entertaining. That's when we hear things about neighbors, mooning their neighbors, like that. Yes, I just said that. It's a hanging offense. You can't steal someone's horse. I don't even know why we're talking about it. It's bad. We don't even speak about something like that. We're not heathens. We don't steal horses. Drunken. You got a gifted membership on Twitch. In the last, was that you, Monica? Or was that V? I cannot remember. It was either Monica or it was V. Got you a gift membership on Twitch. Anyway. There should be no cutting of trees. That is an order. But those are so good, those cases. They get so mad at each other because someone cut their tree. It was V. Yes.
A fingerprint order in place. Do we have the ability to do that now? If not, we'll do it at a later point.
Both times.
All right. So what I'm going to do is I'm going to do a fingerprint order now on that. Go ahead, Mr. Hudd.
He said he did the his fingerprints at the jail both times he was
But
arrested.
not for this one.
Not for this
That's the issue, is I need to link this to your record as well, just so there's no issues there. And so I will go ahead and prepare a fingerprint order. That'll need to be done within the next week. And so by August 14th of 2026. And so in all honesty, Mr. Hood, that kind of adds a third place for you to go today, is downstairs to sign the personal recognizance bond, over to Community Justice Services to check in with your case supervisor. And you'll need to call the Boulder County Sheriff's Office telling them that you have a copy of a fingerprint order and that you need to do that. Hopefully they'll say, come on in, and they'll get it done right there and then. Otherwise, you have to go back to when they say so. All right?
Okay.
All right. And so we'll go ahead and reset everything to September 9th, 2020.
We actually don't hardly ever have theft either. And you would think there would be a ton of theft cases from houses, from Walmarts, porch pirates, thefts, from restaurants, dine and dash. We don't ever see a dine and dash. I know for a fact dine and dash is a frequent thing. We don't ever see any of those. You know what else we don't see? Like corporate espionage cases or we don't see big people embezzling billions from a company, and that happens every single day. Why do we only get to see domestic violence and DUI cases and every once in a while a murder case? Because I get every single courtroom in Colorado. I get every single courtroom in Indiana. I get a large amount of courtrooms in Georgia. And we've been watching all of Michigan for 6 years now. And I mean, we don't see I'm just saying there's so many different crimes. Why don't we see them?
6 at 8:15 in the morning, and that'll conclude the matter.
Thank you.
Thank you, folks. So, Mr. Hood, just hang out for a minute. We'll get you that order as well as that new setting notice. And just get him the setting notice for the 7-Eleven case. If you do have a setting notice for the newest case, that way the clerks will not be confused when they fill in the bond return date. Okay.
Barbara, come back in. Right.
Your Honor, I am ready on Evan Robinson's matters.
Right. The court is going to call cases 26 CR 367, Longmont case 25M 734, Longmont case 24M 453, Longmont case 24M 1287, People of the State of Colorado versus Evan Robinson. Good morning, Mr. Robinson. All right. How are we proceeding today?
And Florence Seaman on behalf of Mr.
We are not in Longmont at all. We're in Boulder. Sherry, is Longmont in Boulder or is Boulder in Longmont? Why are they doing all these Longmont cases in Boulder courtroom? Because this is Boulder, 100%. I should start calling some judges. See, Kristen, if Middleton gets those cases, we should also get those cases. We should be getting a bunch of other cases.
Mr. Robinson, I just filed plea paperwork in 26 CR 367 and Longmont 25M 734. And then Mr. Robinson would be admitting in the remaining two cases.
All right. Stand by for 1 second.
And I'm happy to put the disposition on the record whenever the court's ready.
All right. All right. Go ahead, please.
So I'll start with 26 CR 367. That case is going to involve a split plea. So he'll be pleading guilty to an added count 3 of vehicular eluding as a class 5 felony. That charge will be pursuant to a 2-year deferred judgment and sentence. Then he'll also be pleading guilty to an added count 4 of DUI as a third offense, which is an unclassified misdemeanor with that charge will be pursuant to 2 years of probation. The terms and conditions of both the deferred judgment and the probation sentence will be substance abuse evaluation and any recommended treatment, substance abuse monitoring at the discretion of probation, a fine, and an amount open to the court. The statutory range is between $600 and $1,500. 84 hours of useful public service, a Mothers Against Drunk Driving panel, no alcohol or non-prescribed drugs, 1 year of jail suspended upon completion of the substance abuse treatment, no driving with without a valid driver's license or insurance, and standard terms and conditions of adult supervised probation, as well as 75 days of jail. And the plea paperwork that the court has says 90 days. We've agreed to reduce that to 75 days today in court because he does, this case was originally filed as a misdemeanor and he was arrested and spent around 15 days in jail on that case, which has since been dismissed. But I wanted to give him credit for that. So that's why I reduced it to 75 days. Then moving on to Longmont 25M 734, he'll be pleading guilty to an added count 2 of attempted assault in the 3rd degree as a class 2 misdemeanor, and that is not an act of domestic violence. In that case, he'll be sentenced to 18 months of probation, which will include no alcohol or non-prescribed drugs, mental health evaluation and any recommended treatment, anger management evaluation and any recommended treatment at the discretion of probation, no new law violations, compliance with the protection order, substance abuse monitoring at discretion of probation. All other counts in those 2 cases will be dismissed. And then in 24M 453 and 24M 1287, he'll admit to having violated probation. Probation will be revoked and reinstated with a new term in all original terms and conditions. I believe that's it.
Okay. Does that sound all correct? All right. All righty. And so let me go ahead and start. Mr. Robinson, were you here earlier when I advised the gallery as to your rights?
Yes, Your
All
Honor.
right. In addition to the rights that I had also had gone through with regards to being on probation, I want to make sure that you understand the following rights are a little bit different but similar. And so you do have the right to have an attorney. One has been appointed for you from the public defender's office as you had qualified. You have the right to have a hearing on the complaint. At the hearing, the district attorney would need to prove either by a preponderance of the evidence because you violated technical violations such.
I like this, Judge, but I have a question for you guys. There's 20 people here. I have a question. So, what do you guys think about premieres? I don't want to force people to come to a premiere, you know, when they don't like it. Or, I don't want to not provide a place where you guys can chat with each other every day because I'm working. So, I don't know which, I don't want to do the wrong thing. I don't want to make you guys sit through 2 hours of, court that's boring because there's nobody here to pause it and talk a lot. So this week, if I can't make a live stream, which might happen multiple times, would you rather me cancel the live stream or put a premiere up? I'll just do a poll. And if you could possibly answer the poll, there's 21 people here, but one of them might be me. So, I'm going to put a poll up and say, would you rather have a premiere or no live stream or nothing? But, alright, I'm going to do a poll now. I'm going to let it run for like 5 minutes.
As not showing up to your probation appointments, not doing the classes that you're required to do, those kinds of things. Or if it was not a technical term and you're accused of a new law violation, the district attorney must prove that allegation beyond a reasonable doubt. By entering guilty pleas to these two new cases, you're kind of admitting guilt, and so that could be used against you as well at the hearing. At a probation hearing, you have the right to confront witnesses that are called against you. You could present your own witnesses and evidence, and you could issue subpoenas to compel witnesses to appear for you. You could decide at that probation hearing to either testify on your own behalf, and if you choose to remain silent, that cannot be held against you. Do you understand those rights with regards to the probation violation?
Yes, Your Honor.
All right. And so let me kind of go through my general advisement. I have heard that you are willing to enter a disposition that's going to resolve all of your cases. I won't repeat it on the record because I just heard it. But is that your understanding as how all your cases are going to be resolved?
Yes.
All right. How old are you?
45.
How far have you gone in school?
Bachelor's degree.
All right. And again, this is the first question.
Can I just tell you about $2 bills, Jen? I understand that giving your server a $2 bill might seem like a great idea. It might. Knock it the hell off. I mean that in the nicest way possible. Believe it or not, the reason your server is bringing you food and drink and smiling and talking is to earn money to pay her electric bill. That's the reason. That's what the goal is. The goal is I have to pay the electric bill or they're going to shut my electric off. So when you give me 10 $2 bills, that's really nice of you. That's $20. That's nice of you. It really is. But I can't put that in the Mac machine. So now I got to figure out a way to take it to a bank and get it into my bank account, which I never, ever, ever, ever do. So the $2 bills sort of just get moved and moved and moved and moved and moved and lost and found and lost. And then sometimes I give them to my nephew for his birthday. But that novelty is really just like an extra layer of work I need to do now to get paid for your table. So really, if you got $2 bills, give them to a child or someone that would love novelty money. But people who need money to to pay their bills, $2 bills are not acceptable. That's what I do, Jen. I'm a huge tipper. I just am. Unless I mean, you have to do something. Even if you're a bad server, you get a great tip from me. Unless you actively piss me off, which does happen, you know, one person this week, it wasn't from me, it was my daughter. She gave someone a $4 tip for door dashing to our house. Now, just so you know, we live far, far away. But DoorDash charged my daughter like tons of money in fees. That's fine. The delivery driver does get some of that. They just do. And normally that delivery driver would have gotten at least $20 for driving at minimum. That's the minimum. But the delivery driver took her order to the wrong house. Now, there are no houses near me. I live far from other houses. So my daughter like texted the delivery driver and says, "There's no food out here. You said the food was here." He said, "Yeah, I dropped it off." She goes, that's not my house in the picture. I don't know what that is." He said, "Well, you set the pin wrong when you ordered it." She goes, "I didn't set a pin when I ordered it. I just put in my address." He said, "You have to learn how to set the pin better when you're ordering your food from DoorDash." So she gave him $4. But you have to go out of your way to piss me off to get a bad tip. Bobby, on the other hand, Bobby's like, "Why do I have to tip servers? That's their job, to bring me my food and drink." Bobby, that's stealing. That's stealing. You can't just not tip a server, right? No, I'm not going to Monticello then. No, I'm just never going there. If someone tries to give me a $2 bill. No, when I get a tip, $2 bills, I thank them profusely because they are giving me a tip. Thank you very much. I appreciate you. Thank you. But man, if you have something other than a $2 bill, try that instead. It looks like Premier's won by a lot. But I'm clicking around and it's not letting me end the poll. There we go. So I will have Premiers up for all the spots that I can't make it to. It's going to be a rough week, but we're going to get through it, guys. I promise. Just hang in there. It will get better soon.
That I should ask, but do you read, write, and understand the English language?
I do.
All right. You're represented in this case by the Office of the Public Defender. Have you been satisfied with their performance in this case, and specifically that of Ms. Seaman?
Very much so.
All right. And are you on any kind of alcohol, drugs, or medication that would impair your ability to understand what is going on here today or the paperwork that you have completed?
No, Your Honor.
All right. And so with regards to the plea in this case, my understanding is with regards to case
Shut up, Maiko.
26 CR 367 that you're going to be pleading guilty to 2 added counts. Those added counts state the following. Count 2, that on or about February 28th, 2026, you, Evan Greenridge Robinson, while operating a motor vehicle, unlawfully, feloniously, and knowingly eluded or attempt to elude Officer Gladys Perez, a peace officer, also operating a motor vehicle, and that you knew or reasonably should have known that you were being pursued by the peace officer and operated the vehicle in a reckless manner in violation of Colorado law. I understand that you're entering that plea to take advantage of the plea agreement in this case, and so there's not a factual basis to that. But you are pleading guilty to count 3, driving under the influence as a third or subsequent offense. That alleges that on that same date in Boulder County, Colorado, that you, Evan Greenridge Robinson, unlawfully drove or operated a motor vehicle while under the influence of alcohol, drugs, or both. Further, that you had a prior conviction for driving while ability impaired on December 10th of 2010 in Boulder County, Colorado, in case 2010 M2.
Okay, I'm not going to do this one as a poll, but I have another quick question. 'Cause speaking of this guy's got a DUI now. A third one. A third DUI. I was with some people. I was working, and one of the other servers was talking about a DUI, and someone said, "Yeah, but everybody has at least one DUI." And it took me aback a little bit because, hi Margaret, because like the other servers sort of agreed. everybody has at least one DUI. What? Is that true? You don't have to tell me, yes, I have a DUI, or no, I don't have a DUI. I'm not asking anyone to confess their sins in chat. What I'm asking you is, do you think it's true that most people do have at least one DUI? Because that sounds crazy to me. I don't feel that most people have at least one DUI. I feel that's wrong. But maybe I'm just, out of the loop. Sorry, I was just blowing out my incense. Oh, it smells so good. Oh, Maiko's got a DUI. I'm just kidding, Maiko. Yeah, I guess it was restaurant workers, so there's that. Okay, that's how I feel. I feel that DUI is not normal for everybody to have. I don't even think it's normal for everybody to have a crime on their record. I don't think that that's a normal thing. I think most people do not. Maybe like a traffic violation, speeding or running a red light is one thing, but I mean like a crime. I think it's normal that most people have never been caught and convicted of a crime. I'm not going to say most people have never committed a crime. I'm not stupid. I'm saying most people have never been caught and charged with a crime that has been put on their record. I don't know. Feels like I go through 350 million DUI cases every single day. 1987 was a year to drink, though, Maiko. Great music. 1984, 1985, 1986, 1987. We didn't know how good we had it those years with music. But that's okay. That's fine.
7-7, that you had a second driving while ability impaired conviction on July 17th, 2007 in Boulder County, Colorado in case 2007 T3836. And so this would be considered a third or subsequent offense. Do you understand those elements that I have explained to you as to each of those particular charges?
Yes, I do.
All right. With regards to the vehicular eluding charge, in that you're going to be receiving a 2-year deferred sentence, but I need to advise you of what the possible penalties are if you were to violate the terms and conditions of that deferred sentence. If you were to violate the terms and conditions, you could be facing a prison sentence between 1 and 3 years in the Department of Corrections. With aggravating circumstances, it could be as many as 6 years, and with mitigating circumstances, as little as 6 months. You also would be facing, if you were sentenced to the Department of Corrections, to a parole period of 2 years. You would also be facing a fine of up to $100,000. For the driving under the influence charge as a third or subsequent offense, the possible penalties are, is it 60 days as the low end? I think it's 60 days.
Yeah, for the third deal.
Thank you. 60 days to 1 year in the Boulder County Jail. You also could face a fine between $600 and $1,500. Do you understand those possible penalties?
Yes, I do.
All right. In case Longmont case 25M 734, in that case, my understanding is that you're going to be pleading guilty to an added count 2. That added count 2 is a charge of criminal attempt to commit assault in the third degree. That alleges that on or about July 1st of 2025, that you engaged in conduct constituting a substantial step towards the commission of the crime of assault in the third degree, and that you unlawfully and knowingly or recklessly attempted to cause bodily injury to Tracy Schultz in violation of Colorado law. That's a Class 2 misdemeanor. The possible penalty on that offense is up to 120 days.
I got a speeding ticket like 30 days ago. It was an accident. I was in a deep discussion, and I wasn't paying attention to what I was doing, and the road went from 55 to 35 real quick. I knew this, though. It's not like I didn't know this was happening. I've been driving this road for 50 years. So I knew, but it didn't register, and I was going 52 when it hit 35. And they gave me a speeding ticket, $188.
days in jail and a fine of up to $750. Do you understand the elements of that particular offense?
I do.
And do you understand the possible penalty for those offenses?
Yes.
All right. Turning next to the probation violation case in Longmont 24M 453. In that particular case, you had entered a guilty plea to assault in the third degree as a class 1 misdemeanor. If you admit a probation violation, you'd be facing a potential jail sentence of up to 364 days in jail and a fine of up to $5,000. Do you understand that?
I do. Yes.
All right. And then finally, in Longmont case 24M 1287, in that case, you had entered a guilty plea to a violation of a protection order as a class 1 misdemeanor. Again, if you admit a probation violation, in that case, could be facing up to 364 days in jail and a fine of up to $5,000. Do you understand that?
Yes.
It's a lot to go through. Do you have any questions before I ask how you would like to plead in each of these cases?
No, I do not.
All right. So let me kind of go through one at a time. In case 26 CR 367, how do you plead to added count 2 vehicular eluding? Guilty or not guilty?
Guilty.
And with regards to added count 3, driving under the influence or as a third or subsequent offense, how do you plead guilty or not guilty?
Guilty.
All right. With regards to case Longmont 25M 734, how do you plead to count 2, criminal attempt to commit assault in the third degree, guilty or not guilty?
Guilty.
And then with regards to your probation in case Longmont 24M 453, would you like to admit or deny the probation violation in that case?
Admit.
And then finally, in case Longmont 24M 1287, would you like to admit or deny the probation violation in that case?
Admit.
All right. The court is going to find after discussion with Mr. Robinson that he is represented by counsel, that he is knowingly and intelligently entering his pleas in each of the cases. I will go ahead and enter each of his guilty pleas in the 2 cases and enter convictions. I'll also enter his admissions in the 2 probation violation cases and revoke his probation there. From the prosecution, Ms. Hosinger, was there anything else that you'd like to say with regards to sentencing in those cases?
No, Your Honor, I think this is an appropriate disposition. I would just ask the court to accept the disposition we've worked out. And
I wasn't traveling because I had a valid driver's license. My car was registered to me, and I had insurance in my name. So I wasn't traveling. I was definitely driving. 52 in a 35.
And there is not going to be any restitution requested in the 2 prejudgment cases.
All right. Thank you. Ms. Seaman.
If the court is going to be accepting the disposition, I have nothing further.
All right. And I think that the disposition is overall fair based on the facts that I've heard in this particular case. Mr. Robinson, you have the right to make any statement that you'd like to the court before I enter any kind of sentence. I wanted to welcome you to do that at this point.
Thank you. I've written about a page. It shouldn't take too long.
Go ahead. Take your time.
Your Honor, I am a firm believer in rehabilitation and redemption. But I also feel that in order to truly change, one must have the desire and the will, the education and means, and the support and time to do so. In other words, one must be committed, able, informed, and patient enough to even attempt such a thing. Many fail time and again, a few succeed and give us hope. I believe
Contempt of court. Please give him contempt of court for making us listen to this. Please, Lord, please.
I have the ability to change and be a force for knowledge, peace, goodness, and mercy in this world. I have a problem with alcohol abuse. I have anger issues. I've had depression my entire adult life. I have squandered numerous great opportunities and thus far wasted what talent I possess. I have made awful decisions that have put others and myself at great risk. I have selfishly given up on self-care and regard for myself and often others. I have lost love because of my temper and my choices. I do have plans, goals, even dreams, although much deferred, I'm afraid. I have skills, interests, and passions. But someone wise said there is nothing more common than wasted talent, more tragic than unmet potential. Effort and determination and persistence matters. I feel I have largely wasted my time on this earth and life is getting short. I won't presume to insult the intelligence.
Too late. Marty, thank you so much for hiding. You and me are hiding together. Hi, Steven. Hello.
Of this court, this incident was not an aberration in my lifetime. I am an alcoholic, like both my grandfathers before me, and alcoholics are notoriously secretive and untruthful, even if they have glimpses of clarity. I would like to apply for sober living when I am released. I have a friend in the program and he has found great success with it so far. I know I need help, and I will do anything to get it, because my will to live is at its lowest ebb that I've ever known. Thank you for listening to the statement.
Thank you, Mr. Robinson. Mr. Robinson, I appreciate your statement, and I appreciate the fact that you recognize kind of where you are right now. I encourage you again, there are some programs that are going to be available at the jail. You've talked about entering into a sober living facility, and I think that that is a great option as well. But I don't want you to give up on yourself. One of the things that I have known in my time here in the criminal justice system is that I never let a particular event define who someone is. What I want them to be able to do is learn from that event and move on. And so it's really your actions after these particular events that I think are going to define you more. And you have the ability in this particular case, especially given the opportunity of having a deferred sentence with regards to the vehicular eluding charge, to have that come off of your record after a period of 2 years. And that might seem like a really long time, but what I will tell you, and you might already know this based on your prior instances, but in every single case that I've seen where someone struggles with alcohol, you go back to that mantra of just one day at a time. That's really what you're looking for, is going into that next day and planning forward from there. And I hope that you're able to do that and get the help that you need moving forward. The court is going to impose the following sentence. In case 26 CR 367, as to count 2, the court will accept the disposition. I'll impose a 2-year deferred sentence as to count 2 with a concurrent probationary term as to count 3, the driving under the influence charge. Both of those will be supervised by probation. Conditions will include a substance abuse evaluation and treatments as recommended, substance abuse monitoring, and I think the substance abuse monitoring is mandatory at least for the first year, but that'll be at the discretion of probation ultimately. Based on the facts in this case, the court has the ability to impose a fine between $600 and $1,500. As this is a third offense, the court will impose a fine of $1,000.
Kelly, thank you so much. I appreciate it. He will do good if he believes in that mantra, one day at a time. Nobody told me this. I didn't know this was going to happen. I quit smoking like 2 months ago. And I started smoking when I was 9. And I'm 53. So I quit smoking 2 months ago, right? And it was fine. I did great. I quit smoking. And the reason that I quit smoking was selfish. It wasn't so I could be here for my kids or health reasons or blah, blah, blah. No, I just couldn't afford it anymore. They just got too expensive. So I quit smoking, right? Well, starting like a week and a half ago, I don't even know what's going on. I'm living my life. Everything is fine. I'm in a great situation compared to the situation that I was in 2 months ago. Everything is, yeah, some things are harder, but everything else is so much easier and life is so much better. I wish I could describe how great my life is right now. I mean, it's hectic and it's hard, but you know, I just got to work a little bit harder but out of nowhere, I get hit with I just need a cigarette. I need a cigarette. I need a cigarette. I need a cigarette. And it doesn't let go. It gets into my head, and they say, you know, one day at a time. It has been like every day for a week now. Before I think about food, which I love food. I think about food all the time. I think about cigarettes. Like, where are my cigarettes? Where did I put my cigarettes? Oh, wait, I don't have any cigarettes. Oh, I need a cigarette. Oh, I want a cigarette. It's constantly playing in my head. I need a cigarette. I want a cigarette. I need a cigarette. And I just want to scream and punch somebody. Luckily, I'm also extremely lazy. I am a very lazy person. So when I think about what I would have to do to go get a cigarette, I would have to drive for an hour. I don't have another hour in my day. I can't go to the store to get a cigarette. The store is so far away. So, but I know just one cigarette will kill me. I know it. Just one cigarette will ruin everything. But my head tells me all the time, you can have just one. Look how far you just made it 2 months. You can make it, you can do it again. It's really easy. You did it. You could just have one cigarette, throw the rest of the pack away. I saw a lady smoking outside of my job the other day, and I was going to run out and say, I'll buy one cigarette off of you for $20. I didn't. I'm not going to. Don't worry. But out of nowhere, month 2, guys, it is unreal. It is intense. I would venture to say that, when you're a brand new parent, you have your first baby, you bring that baby home. It's like you don't sleep. You constantly just make sure that thing is breathing. Is that thing breathing? Is it still breathing? Oh my God, we have to put a camera on that thing all the time to make sure that it's still breathing. That's how it is. It's worse than me having a newborn baby, my first newborn baby in the house. Like, it's constantly there saying, you have to go get a cigarette. You have to go get a cigarette. But I'm not going to. I'm not. It's just month two, something happened. It'll go away. I'm not going to go through quitting all over again. That was too much to go through once. I'm not going to do it all over again. If I even smoke one cigarette, I have to go through all of that all over again, or I die a smoker, which I will, and it's so expensive, and it's not a great habit. But this guy will do well if he just remembers one day at a time, which I don't think he will. I think his anger issues, I think he's talking about drinking so much, he's not talking about his anger issues. But maybe he'll learn that in the 12-step program. Who knows?
Mr. Robinson, what I don't want you to take from this with regards to the fines and costs are the fact that this is all this insurmountable hill that you're looking at. The folks at probation actually understand the position that everyone is in when they kind of come to that front desk. They'll get you on a payment plan so you're able to get through everything. So I don't want you to kind of feel overly stressed that I'm piling on all of this stuff that you're never going to be out from under. That's not my goal in this particular case. At the same time, you also acknowledge that in your statement that there has to be accountability for the conduct as well. The court will impose a condition that you complete the MAD victim impact panel, that you have no alcohol and no driving without a valid driver's license. I will suspend a 1-year jail sentence on condition that you successfully complete probation. I will also impose all the standard terms and conditions of adult probation, and I will impose a 75-day jail sentence as that's what has been agreed to by the parties. With regards to case 25M734 out of Longmont and count 2, again, the court enters the conviction as to a charge of attempted third-degree assault. The court will note that this is not a domestic violence related offense. The court will impose a concurrent 18-month probationary sentence with a condition of no alcohol, an alcohol evaluation, and treatment is recommended. That's going to be concurrent to your the one that you're doing in the DUI case. So I don't want you to think I've got to do 2 separate things. All of these are going to be kind of meshed together. I am going to require that you complete an additional mental health evaluation, and treatment is recommended. An anger management and treatment is recommended. Substance use monitoring at the discretion of probation, that you comply with the mandatory protection order. Am I missing any of the conditions, Ms. Hutzinger? I wrote them down as fast as you were telling them, but I missed one.
That's okay, Your Honor. Yes, I believe there's also the 84 hours of useful public service on the
DUI,
on the CR case.
Thank you. And so with with the 26 CR 367 case, there is a condition that you complete 84 hours of community service work as well. In cases 24M 1287 and 25M734, I'm going to revoke and reinstate probation. I'm going to have those run concurrent, and I'm going to key them to the new 734 case. So it's going to be a new 18-month probationary term for you, Mr. Robinson, as to each of those cases as well. And so that's a benchmark too for you to kind of strive for. The DUI probation, again, that's a 2-year term. But again, if you're able to make it up to that 18 months, you're going to be able to get off probation in those 3 other cases. And that's an important benchmark because it's going to show that continued success that you'll have. And so again, all the original terms and conditions from that case are imposed as well. I'm not imposing any additional penalty. Ms. Hotzinger, anything else?
It's funny, when you're a smoker, it doesn't matter how much money you make or don't make. It doesn't matter if you can afford the cigarettes or not. You get cigarettes every day. You just get them. Like, your whole life, you wake up in the morning and it's like, gotta get cigarettes. I gotta go get cigarettes. You don't even think about, oh, you have to pay the electric bill, or, oh, your son needs shoes, or, no. I have to go get my cigarettes first, period. I need my cigarettes. You afford them. You just do. It's the only thing you afford out of everything in life.
I don't believe so, Your Honor. We didn't discuss whether he'll be going into custody today.
I assumed he was.
That was my
third offense
as well.
All right. Ms. Seaman?
And that would be his preference, so he can just get everything started.
Okay. All righty. And so, Mr. Robinson, I want to again wish you good luck with everything. And again, I hope that you're able to make a turn and make that turn for the better and start kind of climbing out of the hole that you see yourself in right now. I'm going to order that the jail sentence start today. I've got some deputies that have come in and they're just going to go ahead and explain to you what the next steps are. All right.
Thank you.
All right. Good luck with everything, sir.
I'm ready on Michael McMillan's cases.
Thank you. All right. The court is going to call the Michael McMillan matters. Give me a second while I get through the list. I have 26 CR 572, 25 M 2226, 26 CR 594, 26 M 402. That's a Longmont case. Longmont case 26 M 128. Longmont case 26 M 117. Boulder case 25 T 1902. 25 CR 1418. Boulder case 24 T 1531 and Boulder case 26 M 961. These are all titled People of the State of Colorado versus Michael McMillan. Mr. McMillan, do I see you in front of me right now?
Yes, sir.
Thank you for appearing. How are we proceeding today? What I've noted, folks, is this is the kind of reset first arraignment based on the new case. I know that there have been other cases that have been hanging around for a while, but with these all conglomerated, this is kind of the first overall arraignment.
And it's our request that these cases be set over to September 18th.
Ms. Hotzinger, any objection?
Your Honor, I have no objection to this set over and setting to September 18th. I did just want to make a brief record about probation compliance. Mr. McMillan's probation officer, Ms. Yoder, is present in court today. I'm asking that he be ordered to check in with her after court this morning. I have spoken with Ms. Yoder, and he hasn't called her and has missed all scheduled UAs since April 1st of 2026. And hasn't attended.
Okay, then he gets remanded. So, you commit a crime, you go in front of a judge. You get to put on probation in lieu of jail. So if you don't do what you're supposed to do on probation, then you go to jail. He goes to jail. Remand him.
At a probation appointment since March 13th. So he's basically just not in compliance with probation. And every time we come back to court, he's picked up more cases. So I do have concerns about ongoing compliance and will be watching if he has more cases come up before September.
All right. Stand by for just 1
You'll be watching. You didn't hear enough already?
second, folks. All right. Ms. Seaman. Anything else that you wanted to respond to with regards to that?
Mr. McMillan has already told me that he'll be checking in today. He didn't realize that he needed to continue to check in after the probation complaint was filed. He also will be starting an inpatient rehab program this Sunday in Morrison called REVOKE Recovery.
All right. And did your probation officer know that you've enrolled in that?
I'll be doing that today.
Doing that today? All right. And so we're looking at resetting this on September 18th.
Yes, please.
All right. And so the court will grant the request. We'll continue all of these till September 18th, 2026. With regards to the new program, how long is that program?
It's 15 days of the detox, and then it could be another 30 days after that.
All right. And so assuming that...
Okay. Am I just being biased, or is he drunk right now?
Seaman, I don't want to question the math on setting this on the 18th. My worry is that if he does the 15 days and then re-ups for 30, we could be running into a problem because I think that goes beyond September 18th. Do you want to just confer with Mr. McMillan to see if he wants to appear by video, if he's still in the program?
Yeah, it sounds like if the court would permit him to appear virtually, he can do that.
And I think that's only if he's in the program still.
Yeah.
All right. Ms. Hotzinger, I know that you have concerns, and I do too, with the number of cases.
I do have concerns. I would object at this point unless and until I get proof that he's in the program through either a treatment provider or something of that nature, something filed into the case.
All right. Ms. Yoder, did you want to say anything? All right. Alrighty. So with regards to additional court orders today, I'm going to order that you report to probation with Ms. Yoder today, that you comply with the terms and conditions of your probation, including any kind of immediate substance use monitoring that is going on or otherwise, and that you make all of your appointments with Ms. Yoder going forward. You're still on probation, even though a complaint has been filed. You still have to comply with the conditions because that's a condition of your bond. And if I hear from Ms. Yoder that you're not complying with conditions of your probation, that would necessarily be a violation of your bond, and it might make me rethink whether or not you should be out on bond. All right.
Yes, sir.
So with regards to the next appearance, here's what I'm going to do. Ms. Seaman, I'm going to require that be in person unless you're able to file something with the court that indicates that he is currently in that program and that program requires him to stay within the confines of the REVOKE recovery. And if that's filed, then I'll authorize an appearance over WebEx. I'm also going to ask Mr. McMillan that you cooperate with probation. Since probation is going to want to see the treatment that you're doing, she might ask you for a release to confirm that you are enrolled in the program and how you're doing in the program, because that's important for her to know. So I'm going to order that you sign any releases as requested by probation.
Yes.
All right. Alrighty. We will see you on September 18th, 2026, 8:15 in the morning back in this courtroom. Thank you for appearing. Good luck with the treatment.
Thank you.
Thank you.
Go for it.
Judge, at this point, I think we could call Mr. James Simpson.
Okay.
Oh, actually, let's not.
All right.
Sorry.
No, you're fine. Stand by for just 1 second.
That would just be funny if he let the third DUI guy off. He sent the other guy who just did all of that, picked up new cases, never did any of his drops, blah, blah, blah. He sent him on his merry way. But this lawyer calls a case and the person's not there. He holds her in contempt of court. That would have been funny. That would have been high quality. But it didn't happen.
Good after morning. It's not afternoon yet. It's after morning.
Hi there. Thanks for your patience with me this morning. We already have Miss Saldana's cases.
Right.
That's 3.
All right. The court is going to call following cases. These are cases 26 CR 206, 26 CR 85, and Boulder 25 T 543. These are people of the state of Colorado versus Angelica Saldana. And Ms. Spangler, good morning. How are we proceeding today?
Good morning. I'm asking for a brief set over. And if the court is available, Ms. Saldana and the district attorney are available next Friday, the 14th.
Bye, my
People are
gal.
available.
We are very full. Sorry, the first date, just so you know, kind of where I am on my sheet. Wow. I think the first date that I have is Wednesday, September 9th. Nope, I'm wrong. I can do Wednesday, August 19th.
People can accept that.
We can accept that as well. Thank you.
Alrighty, so I'll go ahead and continue the 3 matters to Wednesday, August 19th, 2026. That'll be 8:15 in the morning back in this courtroom, all right? All right, stand.
All right, guys, we made it. We made it to the end. Thank you so much for coming out today, guys. I really, 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 really appreciate it. I'll see you all in 6 hours, 7 hours, something like that. Behave, okay? Have a good night. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome